All right, thanks, Giant. So it's actually a pleasure for me to sit down with my friend Stephan. Haven't seen him probably in 8 years or something like that since I moved from Houston. But I've learned a lot from him over the years, and actually just reminded me of those conversations after the event yesterday. He and I were exchanging emails until late in the night. So this has been great. I want to maybe talk to Stephan a little bit about intellectual property, because we didn't get to touch on that in his talk. And this is really his specialty. It's where he's really added a lot of insights, and he's done so from a libertarian perspective. So I think it'd be really interesting to people here. But I want to first relate something, because Stephan, you mentioned as part of your talk, the experiences you've had and maybe the difficulties with communicating with engineers in your role as a patent attorney. Well, 30 years ago, that would have been me. So I was involved in patents at the time. And so before I start, I just want to share my perspective on what it's like dealing with the patent attorneys, which is always interesting. And it actually, to me, it crystallized the case against IP. So when Stephan came with his theories, I mean, I was already primed for it because I'd lived it. And, the typical day with a patent attorney is you sit down, the patent attorney says, tell me about your invention. And you go, okay, well, here. So I've got this thing. Wait, stop. Thing. Like, what are you doing? Oh, we're describing the invention. I'm like, all right, but you can't patent thing. It's like, well, probably not, but let's try. Like, okay. Yeah. What does the thing do? Well, the thing does this other thing. Thing does other thing. Okay. And that's what you're trying to do. He described patents as a patent right as the ability to prevent other people from doing things. And if you're a company, you want to prevent other people from doing everything if you can. So you're going to get the broadest patent you can to stomp out competition as effectively as you can. And it's because of that when you see ridiculous patents like the iPhone, you can understand where they originated from, because the guy says, well, okay, here's my invention. Here it is. What is it? Oh, it's a mobile phone. Okay. Apparatus. It's big screen for communication. Look, dude, this is like a touch screen, right? Rectangular. You're not hearing me. It has a camera, with rounded corners. Dude, the antenna is built into the case, okay? But no, they're getting the most simplest, broadest thing to prevent anyone from doing anything. And you could see, I can just imagine the Samsung engineers opening up those patent claims and going, oh my God, those bastards. It's like, they've patented a rectangular object with rounded corners. What are we going to do? And so this is the difficulty with IP, is it actually inhibits innovation, because the first thing we have to do as engineers is figure out where all the landmines are. How am I going to get around this one? It's a rectangle. How am I going to get around this one? It's rounded corners. And so the only people that can engage are big companies with big patent portfolios that you can cross-license, right? This is like weapons, basically, right? So it's like, okay, you're violating my patent, and I'm violating yours, and we'll cross-license, and that's how we get around it. But everyone else, the small guys, are screwed because they got no weapons to play with. So I want to start with, I think, the IP, and this is my practical case against it. But you have sort of a well thought out, well constructed legal framework for the case against intellectual property. So maybe you could just, for people here, just go through that.
And let me briefly preface this. My talk earlier, I didn't really get to finish. I thought I wouldn't, but I focused earlier on property rights and what they are, and how human beings in action employ scarce resources to do things. The second part, which I didn't have time to get to, the second key aspect of human action is knowledge. We have knowledge that guides our behavior. So when you combine those two, and you understand that they relate to the way humans act, and you understand that property rights only apply to one part of that, which is scarce resources, then you understand the case against intellectual property, which I can go into a little bit. And a few people also asked me about the book I mentioned. I'm not a good salesman, obviously. My book is Legal Foundations of a Free Society, and it's free online on my website, and you can buy it on Amazon. So if you're interested, go to stephankinsella.com. So that's where my book is. And you're right about the way we learn all these tricks in engineering, and I'm sorry, in patent law. When you file a patent, you describe the invention, and then at the end of it, you terminate with these sentences called claims. And the claims mark out your metes and bounds of your invention, which is what you get protection on. And you can have a number of claims, and every claim is different. And what you do is you start with the broad one first, and you hope you get that one allowed by the examiner or that it upholds in court. But if it doesn't uphold in court, then you have narrow ones. So you might say, I claim a device, but you won't get a patent on that. So I claim a smartphone with the following features. But then you might add in the dependent claims, oh, it's red or whatever, because that's what my competitor is likely to do. So you have this spectrum of claims, and you do that in part. And everyone says that one of the benefits of the patent system is that it discloses information that otherwise people wouldn't disclose, which is total BS because, first of all, we write the patent application in a way that's obscure to you describe the bare minimum you need to get the patent, and it confuses people. So you have all these engineers at competitors being paid to read through these patents, trying to make sure they don't step on them. That's all. But they don't really learn from them, because when you disclose your invention in a patent disclosure, which you have to do to get the patent, that's called the patent bargain. The idea is the government gives you a temporary monopoly for 17 years in exchange for you disclosing things to them that you would have kept secret forever. But the truth is, in almost every type of product, when you sell it, you disclose what it's about. You can't keep it secret in most things. So it's called inevitable disclosure. The disclosure is inevitable. So when you file a patent application on your product that you're selling and you get a patent on that, you're disclosing something that you would have had to disclose anyway. So the bargain is one-sided. The only part of the bargain is you're getting a monopoly to protect you from competitors. And it results in what Albert described. Everyone says, oh, patents are for the big guy, or copyright's the same thing. If you don't have this, it's going to screw the little guy. The big music companies or the big companies are going to screw them over. They don't know what they're talking about. This is just propaganda by the big companies. What happens is that most of the patents are owned, the inventions are owned by the employer under the work for hire doctrine. And so the company owns it. The company's the patentee. The company is the owner of the patent. And so all of these patents on inventions are accumulated in these war chests by these large corporations like Motorola and IBM and Apple. And when one of them invents a new thing like a smartphone, then they sue a competitor like Motorola or vice versa. And you have the smartphone war. So you have all these lawyers go to town, and they're being paid millions of dollars fighting each other in court. And at the end of the day, after 7 years of this and tens of millions of hundreds of millions of dollars of fees being paid to all these patent professionals, guess what they do? They do what Albert said. They sit down and they say, well, my stack of patents is 2 feet tall. Your stack of patents is 18 inches tall. So let's do a cross license with each other. And then we can go about our business. We can keep making our competing products. You can make your Android. I can make my iPhone, and we have a license from each other. So we're not going to sue each other anymore. Maybe one will pay one a license fee because the stack of patents is different, but they pay a fee. They go on. Now, of course, what happens is this means there's like 2 or 3 smartphone makers right out there, the ones that can afford to sue each other and make a deal. And then they just pass these costs on to the consumer in the form of the product price or reduced innovation. The little guy who says, "Oh, I've got a great idea for a new smartphone," he would be sued into oblivion by these big guys. He doesn't have a 2-foot stack of patents that cost $17 million to acquire to countersue them with, or the $3 million to pay lawyers to defend himself in a lawsuit that he might even win, but he can't afford to litigate, right? So that's the way that these patents reduce competition and give rise to oligopolies and cartels or monopolies even in some cases. So, what is the case against patents other than the fact that it destroys innovation, impedes things, and gives people state-granted monopolies? That's enough. The 2 main arguments you hear today for patents is the utilitarian argument and the sort of natural rights argument. The utilitarian argument is that if you don't have a monopoly period where you're free from competition for a while to sell your new pharmaceutical or whatever, people can just copy it, knock you off, compete with you too easily, make it too hard for you to make a profit, And therefore, that's a market failure because I wouldn't ever engage in the research and development in the first place. So I'm not going to make the drug in the first place. So if you don't have the government come in and fix this market failure by granting these monopoly privileges that give you the right to be free from competition for a little while, then you're not going to produce it in the first place. So we have market failure. So the government can fix this and make us better. So I'm from the government. And I'm here to help you. That's the idea. That's the utilitarian idea. There's no evidence for this, of course. This is the idea that you can't recoup your costs because there's market failure. They don't want to put it that way because they pretend to be pro-free market, and good free marketeers don't believe in market failure. We actually understand that true monopolies can only arise when the government grants you one. And guess what they come from? They come from the government granting you things called patents. In fact, the antitrust law, like in competition law and antitrust law, penalizes you from having a monopoly. And guess what the danger is in the U.S.? That if you abuse your patent right and you get too much monopoly power because you abuse your patent right, then you could be in trouble with the FTC for antitrust infringement. So we have a schizophrenic state which grants laws saying you can't have a monopoly. By the way, here's a monopoly, but don't abuse it. What does abuse mean? I don't know. Let's go to court and find out. Pay the lawyers to figure that out. I mean, so the whole thing is just a horrible system. Now, the natural rights argument is that people say, well, if you invent something or you create something, you should be the owner of it. That's what intellectual property is. The problem with that argument is it stems from a mistake that has infused into the way everyone thinks now. And I think it traces back to the argument that John Locke came up with in the 1600s to basically justify individual rights against the government. And he had to couch it in theological terms because that was the way people thought back then, and because people believed in those times of the divine right of kings. So the simplistic idea is that God gave the universe or the earth to Adam and Eve, and then after that you have all these monarchs that descended from them, and so they have the divine right. And although God did say that people can roam the earth and use it and be fruitful and multiply, which basically implies that God gave the resources of the earth to humans in common. They're unowned and people can go out and use them. So Locke came up with an argument to say against Filmer, no, we don't, it's not the kings that we get our rights from. It's God gave it to man in common. So the king, even the king is subject to this right. So it was noble what he was trying to do, but his argument said God gave ownership of the earth to man. Man can use unowned things. He can pluck them from nature by homesteading it, right? By mixing his labor with it. So far, so good. But his argument was this. Everyone owns themselves because God wants them to own themselves, and he gave them their bodies. Therefore, they own their labor. This is his mistake. And therefore, when there's an unowned thing and you mix your labor with it to use it as God wants, then you have to be the one that owns that thing, which is correct. But his reason was you own that thing that you mix your labor with because you own your labor, because it emanates from you. And when you mix this invisible labor force with this thing that's unowned, now you're inextricably tied to it. And if you don't own it, then if you're not the owner, then someone else would be. That's not fair. But the mistake there is that he assumed that labor is an ownable thing. And you don't need to make that assumption for his argument to work. You just need to say, you performed an action with your body that you own, and that action demarcated the thing that you're using, which God wants, right? So you have a better claim to it because you're the first user of it. You don't need to say you own your labor. But when you say that, guess what it led to? This is what we call the labor theory of property. Very similar to something we've heard before, right? Marxism, the labor theory of value, which came from Adam Smith, by the way. So that was a confusing notion of labor. So both of these twin theories, which I think are related, I think they came from Locke, and then Adam Smith got it, then Ricardo, then Marx. And now everyone believes this. Everyone thinks that labor's a thing that you own. It's not just the results of you acting. And one reason they don't know this is they don't think carefully about praxeology. I mean, think about economics. We talk about consumer goods and capital goods. We talk about consumption, or we talk about leisure and labor. So we talk about labor, but there's also leisure, right? Because there's two types of actions. Just like there's two types of goods. There's consumption goods, things you consume for their own sake, and then there's capital goods, things that are intermediate and they help produce the consumer goods. Likewise, for human action, you can divide it into two types. Things we do for their own sake, consumption, leisure, or things that we do to produce something we're going to enjoy later. That's labor, right? Why do we focus only on labor? If you say that you own your labor, why don't we say we own your leisure? They're the same thing. But so that means they're both subsets of a general thing called action. Would it make sense to say you own your action? No, action is what you do with a thing that you own, your body. You control your body, you own your body, you have a property right in your body. But when you act, that's a process, that's a result. So that confusion is why I believe people now, even now, they'll say, well, you own things that you create. But if you notice in the rules that I talked about in my talk, property rights don't rely upon the concept of creation at all. When you own your body, you don't own it because you created it, and you don't own it because you homesteaded it either. You own it because you have a natural connection to it, either because God wants you to have it or because you have a direct connection to it. There's an intimate connection between every person and their body. So the argument for self-ownership and against slavery is pretty intuitive, and most people understand that when they oppose murder, because murder implies that the person you're hurting owns their body. But when it comes to previously unowned external resources in the world that we employ in the world, you have to be the first one to use it. But that's not creating it. That's just finding it, discovering it, and bordering it. So you don't create it. And then also the second way to get it is from contract. That's basically it. Either you find it and you put a border around it by transforming it with your labor. Okay, but it's not because you own your labor. It's just because you're establishing a connection or a link between you and the thing. Or someone owns it and they give it to you with a contract. They sell it to you or they give it to you. Those are the only two ways to come to own something, and neither one has anything to do with labor or creation. But this myth that we own what we create is the reason people think, well, you can own something if you find it, or if someone gives it to you, or if you create it. So they think there's a third way, right? I call this a Lou Rockwell article in 2000, the second rule of homesteading. It's like they think there's an addition, but you can't have an addition. Nothing is for free. You can't print more money to help the poor because you've reduced the value of money, right? You can't inflate money. You can't have positive welfare rights on top of negative rights to your property because one comes at the expense of the other. So if you have negative rights to protect your property, and then the government says now there's a welfare right, that has to come at the expense of the other because you have to tax me and take some of my property to give you that. And it's the same thing with creation as a source of rights. If you identify the way we can tell who owns a resource by saying the first person who found it, which is homesteading, or contractual title transfer, that's it. And if you say, or also creation, now you're coming up with a third thing that butts against the first two. So that's the fundamental theoretical problem with intellectual property. That's a little bit condensed, but that's ultimately, and it's easy to see if you see the two things I mentioned earlier this morning, the role of knowledge and so knowledge guides action, but you can't own it. And when you create a new way of using a resource, that's inventive, but you're not creating a thing that exists on its own. Anyway, that's a pithy summary.
Right. Well done. Well done. While he was giving his talk and we sat down here, it occurred to me that, Stephan, this is like, you are the first patent attorney that I've ever sat down with without being coerced by a boss.
That's a compliment.
And when I met Stephan, actually, it was quite exceptional because there's this quote that I'm sure you've all heard. It's difficult to get a man to understand something when his salary depends on his not understanding.
Right.
And so this is the patent attorney he literally wrote the book on the case against patent law. I thought that's quite extraordinary.
Well, coincidentally, I found out my old mentor, Bill Norvell, this guy I mentioned in the first talk, a lawyer from Houston. I hadn't talked to him in 20 years, and we touched base recently. I interviewed him for my show, and he said he'd read some of my stuff. He goes, yeah, I agree with you. The patent system is bullshit. So if you think about it, a lot of these people will admit it he's retired already, so now he can say it. That's the difference.
Yeah. I want to put a finer point on the point that you just made, because something that really, drove it home for me was, when the government enforces a patent, tell us exactly what they're doing.
Okay.
Right? Because they're actually preventing you from rearranging, manipulating what you rightfully own. So can you just explain it that way? Because that really drove it home for me.
Well, so the way it works is, and generally we libertarians and the free market operates on the presupposition that, we don't live by permission like we accuse people of having lived in the Soviet Union. You have to live by permission. Everything that is not forbidden everything's not permitted is forbidden, right? We're supposed to live in a land where there are not islands of liberty in a sea of restrictions. It's the other way around. We live in a world of liberty where you only are forbidden from doing certain things, like using other people's stuff without their permission, right? So it's a presumption. And so I don't need to say I have a natural right to take a warm bath at night. I mean, I would be enumerating rights forever. I just have the right to do anything as long as I don't use someone else's property, right? As long as I don't initiate force. So the general rule is you can do anything you want, such as compete with other people or copy. That's what competition is. Competition is when you see someone make a successful product that is pleasing the consumer, a book or a new invention or something like that, then, according to the way the market works, the prices are affected. They're affected because money is flowing to the guy that's making a profit now, right? And that sends a signal to people, hey, look, this guy found a way to please the consumer. We used to think that's a good thing, right? That prices send information and that people compete with each other when they notice that someone does something that satisfies the consumer. So the general state of affairs would be that you're free to emulate what they do, to learn what they do. Fast food, pizza delivery places are now popular. You don't just have to go there. Now Domino's Domino's delivers. Now you have lots of people say, well, let's get into that business. Fast food restaurants, let's have wider aisles in grocery stores. That might attract more customers. And then another grocery store chain goes, oh, that's a good idea. They do the same thing. That's competition, emulation, etc. That's the way things work. When the government grants you a patent, unless you hire a lawyer like me to describe some useful thing you thought of, and get a patent on it, you have you can send a letter to your competitor and you can say, hey, listen, take a look at this patent I've got 12 more years left on my term, and we insist that you cease and desist, or we're going to sue you. And they will often say, okay, we give up, or they say no, and I take them to court, and then in the court, I just prove to the jury or to the judge that there's a valid patent. The patent office should have granted it because we do have patent law, and this guy's infringing, and I want you to issue an order to him, number one, to pay me money for all the past damages, past royalties, and let's treble them because it was willful because I sent him a notice alerting him. Now he can't play stupid American, and I also want you to issue an injunction telling him you can't make this anymore. Or they go to the FTC, which is a separate set of courts in the U.S., which stops imports on the same thing. You don't have to see a judge, then you see an administrative guy. Anyway, an order is issued by the court or the administrative panel to this company saying you're forbidden from making this at all. And if you violate it, that's criminal, right? You're violating, that's a contempt of court. So that's how you stop competition. So then what happens is either you want to kill this guy because you don't want competition, you want to rest on your laurels and collect higher money for selling your product at an inflated price, or you go to him and say, okay, I'll let you sell it if you pay me $5, a royalty deal, like Kevin O'Leary talks about on Shark Tank. It's a royalty deal. We just want a taste. That's what patent trolls do. Patent trolls don't make anything, so they don't want to kill the guy they're suing. They want to just hurt him bad enough to make him pay a little. They would just want a taste, as the guy in The Godfather says. Just give me a taste. Don't be so greedy. So that's how it works. It's literally extortion. It's legalized extortion.
Yeah, and I think what you explained at one point was that you're literally preventing someone from manipulating their own body with property that they own.
Yep.
To configure it in a way that would be more useful to society.
Yeah, and this has this works in trademark law and in copyright law as well. Like there have been lawsuits like by these yoga places that have certain yoga styles, and some people get copyright on tattoo designs. So technically, some of these boxers, or they're getting a tattoo on their face, they're walking around with Mickey Mouse on their face, and they're violating Disney copyright. Now, so far Disney hasn't forced them to undergo surgery to remove it or something, but theoretically that could happen, right? or you could be sued for performing a dance move, or that's copyrighted or trademarked, or certain yoga practices. These are just these are illustrations of the fact that if you give someone a property right like this, it effectively makes you own part of their body or their factory or their printing press.
Right. So it's actually a violation of someone else's
Correct.
real property right.
Correct.
The right of their body. So you restrict a pose that they can go in, for example.
Yeah. One example that I give is, we're all familiar with something called restrictive covenants or homeowners associations, because a lot of us live in them or know them. And in these types of arrangements, you have a bunch of houses. Sometimes a developer does it, and he sets it up where everyone owns their house, but there's an agreement between the homeowners, so everyone agrees not to build their house over a certain height, or not use it for a pig farm, or not paint it purple, something like that. What that means is every owner has a negative veto over what people can do. Like, you can do it if you can get everyone to agree with you, but if they don't agree, they can block your use of your house in a certain way. But you've contractually agreed to it. Okay, you've consented to it. Nothing wrong with that. It's just like, if you kiss a girl goodnight on a date, it's fine if she says okay. If she says no, it's assault, right? So everything changes whether the owner consents or not. And for a normal contractual negative easement or servitude, which is in part of a homeowner's thing, it's consented to. Nothing wrong with that. What a patent and copyright does is it grants a negative servitude that's non-consensual. The government just grants it to this guy, and it burdens the property of someone else, even though they didn't agree to it. So that's ultimately the problem with these rights, is they are the government unilateral grant of a non-consensual negative servitude over people's owned resources.
Right. And Stephan, you mentioned a willful violation at some point.
Yeah.
This is how crazy the industry is because of patent law. As a young engineer, I'd be asked to do something, to make something, and boss would say, well, there might be a lot of patents around that sort of thing. I'm like, all right. He's like, but don't read them.
Right.
What? No, don't break them, but don't read them. Why? Because if you read them and you break them, that's worse than if you just broke it.
It's willful infringement. Yeah. So that's the argument is that, the patent system stimulates people to disclose things that they wouldn't have otherwise known, which I already explained is not true. But on top of that, people intentionally blind themselves. They don't want to read them because they don't want to get in trouble. I think it's one reason why you hear a lot of these musicians today, they're sued for copyright infringement for having, like, I don't know, Stairway to Heaven is too close to some other hillbilly song from the 40s or whatever. And then you have a debate about whether it's too close or not, I think in a lot of cases, if you didn't have copyright, people would just be honest. They say, yeah, I think I was influenced by that song. But now they don't want to admit it. Because if you admit, I was influenced by this guy, then you might be admitting to copyright infringement liability. So it makes people dishonest, just like defamation law makes defamation more potent, right? We're also against defamation law, which is like a type of IP right, because when you have the right to sue people for defaming you, then it makes people assume, well, if you don't sue someone when they tell a lie about you, it must be true. So it gives the lie more potency. If there was no defamation law, which is a type of intellectual property right, if there was no defamation law, people would just take accusations of someone's character with a grain of salt, because they would know that they have the right to say it, so why would you believe it? And then their reputation would be on the line. If you start realizing this guy's going around telling a bunch of lies about people will start disregarding what he says. Anyway.
Right. Okay, so I think we're coming toward the end. Yeah, so I'm going to just end with maybe one more question. And this is something new. Like I said, I always learn something with Stephan. We were talking earlier today, or a little bit last night, about the American founding fathers, Thomas Jefferson in particular. I'll let you share the quote, Stephan, but it's kind of an early indication of their objection to intellectual property. And then the more I thought about it, the more I remember reading at some point that, Ben Franklin was a prolific inventor.
Yeah.
And I remember him specifically, he invented bifocal glasses and some musical instruments. He refused to patent them because he wanted the ideas to go around the world. So can you talk about maybe Franklin and then share the quote from Jefferson?
I only remember the basics. I think Franklin was one of the people that he knew he had the right to get patents and he didn't do it. I think maybe it's even true of Jefferson. Jefferson was an inventor of some kind of plow or something like that. Jefferson was ironically the first patent examiner after the patent statute was enacted in 1790, the year after the Constitution was ratified. Well, it was it's in 1789. But Jefferson has this quote saying that he says that when you light your candle, or taper, he calls it, from someone else's taper, now you both have a flame on your candle. And it doesn't take away the flame of the first guy. And that's how knowledge spreads. And that's the unique aspect of knowledge as a resource. It's not the same as a scarce resource. I can't take your bike and you still have it. That's why stealing a bike is called stealing. But you see these ads on TV that says you wouldn't download a car. It's like, well, yeah, I would download a car, because if I download the copy of a car and have a 3D printer in my garage that makes a brand new Tesla, I'm not taking anyone else's Tesla. It is actually not stealing. So copying and stealing are two different things. Jefferson's had that great quote, which indicates an intuition that there's something wrong with these unnatural monopolies that the Constitution authorizes.
Right. And I speculated, I have no idea if this is true, but maybe these founders had bad experiences with the British Crown, having, monopoly rights on the tea trade and other things. And they were, darn sick of it. By then, they realized that maybe there's another way to do things.
Except for the fact that they put it in the Constitution. And I also think that who were the main authors and inventors at the time? It was the upper class, educated class. And they were the ones who stood to benefit from the patents and copyrights. Even if Benjamin Franklin and Jefferson didn't themselves take advantage of it, that is the class that did benefit from patent and copyrights.
All right. I think we're out of time. Thank you very much. Thank you, everyone.